Good morning, everybody. Welcome to the August 20th, 2019 Board of Commissioners zoning hearing. And we're going to have a modified agenda today, so pay very close attention to what John's about to say here. John, it's all yours. Oh, I'm sorry, yeah. I apologize, I was so focused on the change. I'd like to have Chaplain Brad Ferrant from the Cobb County Police Department lead us in the opening invocation, and Officer Ott will lead us in the prayer, in the Pledge of Allegiance. So those who are willing and able, please stand.
Thank you, my Heavenly Father, for your great love to us. Thank you for this day that we can do our business here on earth. We thank you for your love to us. We ask, Father, that you would be with those that will be presenting in this meeting, that you would give them clarity and as they present their cases. We ask that you would also be with the commissioners, that you would give them wisdom and understanding as they weigh the different zoning requests that are made before them, as they keep in mind our community and what would be best for that. We just ask that you'd give them wisdom today. Again, Father, we are so thankful for your love to us. In my Father's name I pray. Amen.
Amen.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you, Chaplain. Officer Ott. All right, now I'll give it over to John.
Thank you, Mr. Chairman. And as the Chairman stated, we're going to run this hearing a little bit differently. So as I'm reading this process of procedure, the withdrawn and the consent agenda, communications will scroll the held and continued cases that we are not going to hear today. So start scrolling. Today, we're going to run this hearing with the following process and procedure. Each case will be called in numerical order. When each case is called, would the applicant please stand and raise their hand to show that they are here? Then we're going to call to see if there's anyone opposed to the case. We would also ask the opposition to stand and raise their hand so they can count it for the record. After recognizing the applicant and any opposition, the applicant and any opposition will be asked to come forward to be sworn in so they both can present testimony to the Board of Commissioners. The applicant will testify first, and then the opposition, if anyone, testifies second. It's important to note that each side only gets 10 minutes to state their case or concerns. There's not a rebuttal process, and there's not a process to reserve your time, so convey all your information to the board within your 10-minute time period. Additionally, if there's more than one person wishing to speak on a case, you may want to coordinate with each other about what you're going to talk about, because each side only gets 10 minutes, and you don't want to cover the same information twice. Then after the 10-minute presentation periods, the board will start to discuss the matter at hand. They may ask one or more speakers to come back to the front for questions or comments. And after that, the board will make a decision to either approve, deny, hold, or continue the case at hand. There are two cases on today's printed agenda which have been withdrawn without prejudice and will not be heard today. First case is rezoning case Z49 of 2019, Vance Jones. This case was withdrawn without prejudice by the Planning Commission. Second case is SLEP 8 of 2019, United Auto Brokers. This case was withdrawn without prejudice by staff and will not be heard today. Mr. Chairman of the Board, there are two cases that have asked for to be withdrawn today. First case is other business number 41. The applicant has asked this case be withdrawn.
So moved.
Second.
Hey,
Discussion?
Is that with or without prejudice?
Without.
Without.
Okay, and any other questions, comments? Call the question. Passes 5-0.
Thank you. Second case is land use permit number 15, Kenneth L. Pikes. They did send an email in last night asking this case be withdrawn, and we would ask the board to consider that request.
Lot 15, right?
Yes.
Okay, Commissioner Gamble.
So moved, and I'd like to, without prejudice.
Okay, second, discussion? Call the question. Passes 5-0.
Okay. I would like to ask people in today's audience, if you have a cell phone, please turn the volume off on your cell phone. Any person wishing to speak before the Board of Commissioners must file a campaign contribution disclosure statement. If within 2 years immediately preceding the filing of a rezoning application, a campaign contribution totaling $250 more is made to a current member of the Board of Commissioners. And I want to remind applicants, opposition, or any interested party that information is due to this board the Wednesday prior to the hearing. And any information submitted after the Wednesday due date may or may not be considered by the board at their discretion. And with that, Mr. Chairman, I'm ready to start the consent agenda.
So the reason we're changing the order today is we have two commissioners that have some other commitments this morning. And in order to accommodate their schedule, we're gonna be changing the order that we're gonna hear the cases. So right now, what I'd like to do is, Cornelius, if you'd scroll through the cases not to be heard.
We already did that.
Okay, I know that. I want you to do it again because I want to make sure, I want you to look up here on the screen. If you see this case up here, that's not going to be heard today. So if you're here and if you see that case up there and you're in the audience, you can stay, but I just want you to know that your case is not going to be heard today, okay? So just scroll through that one more time, all right? Just make sure that people's time is used accordingly. All right, great, thank you, Cornelius. Now, Commissioner Burrow has a motion to add a couple cases to the consent agenda.
Thank you, Mr. Chairman. I'd like to add Z12 to consent, delete to LRC, stip letter and site plan dated August 6 from Kalina Jenkins, to be submitted for the record. And all other staff comments and recommendations. And I do have a copy of the stip letter and site plan to be submitted. And that's for Z12. And then I'd also like to
Okay,
add,
could we just do a motion for that one?
oh, I'm
Okay.
sorry. Motion to add Z12 to consent.
Discussion, call the question. Passes 5-0, okay?
And then I'd also like to add SLUP 7 to consent with the minutes from the Planning Commission dated August 6th and the attached site plan received August 14th and the email from Water and Sewer referencing the location of the wall. And I have that as well for the clerk. Yeah. I have it. No. I gave you Z12, yeah. I'll have to get that, sorry, I don't.
Okay.
Here we go. Sorry.
It's a rainbow we have there in front of you.
SLUP 7, and a letter from East Cobb Civic Association,
we
submitted
have-
for the record.
We have a motion?
Motion to add
Commissioner Burrow?
SLUP 7 to consent.
Do you mean Kent Road neighbors for Z12? Or is that SLUP 7?
Pardon?
Are you talking about SLUP 7 right now or Z12?
SLUP
I'm on
7.
SLUP 7.
Okay, you're fine then.
Okay, we have a second? Discussion? Call the question. Passes 5-0. All right,
I have one addition to OB 46.
okay?
Is the applicant here for other business 46, Five Guys? Need you come up real quick? I would just like to add a stipulation that you will work with me and get final approval to do some landscaping around the property.
Okay.
So be basically just add a stipulation that says that the applicant agrees to get district commissioner approval for a landscaping plan. Okay? All right.
Great. Thank you, sir. Okay, so with that consent now, you have the new consent agenda.
Okay.
Um,
I'll go ahead and read this and add those other two.
Right.
Okay.
Okay.
Cobb County Board of Commissioners, zoning hearing consent agenda for August 20th, 2019. Zoning case Z50, 2019, Maureen Hart, Little Wonders Learning Center. Request rezoning from R20 and NRC to NRC for the purpose of a child daycare facility in land lot 133 of the 17th district. The property is located on the north side of Pat Mill Road, east of Austell Road. The Planning Commission recommends approval to the NRC zoning district, subject to the following conditions. Proposed site plan and building elevations approved by the district commissioner prior to permitting. Applicant developer to combine both lots into one lot. Provide 20-foot landscape screening buffer adjacent to residentially zoned property. Stormwater Management Division comments and recommendations. Water and Sewer Division comments and recommendations. And Department of Transportation comments and recommendations. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to rezone case Z50? Let the record show there's no one opposed.
Commissioner Gamble has a comment.
Yes, John, I'd also like to add stipulation number 7, that the Austell Road design guidelines, where applicable, will be applied.
Okay,
Thank you.
got it. Okay, moving into land use permits on the consent agenda. LUP 17 of 2019, Burn Hickory Church of Christ Incorporated request a land use permit renewal for the purpose of a daycare facility in land lot 291 of the 20th district. The property is located on the north side of Burn Hickory Road, west of New Salem Road. The Planning Commission recommends approval for 24 months, subject to site plan received by the zoning division on May 2nd, 2019, with the district commissioner approving minor modifications. Daycare-related banner sign to be no larger than 3 feet by 5 feet, and Department of Transportation comments and recommendations. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to LUP 17? Let the record show there's no one opposed. Moving into special land use permits, SLUP 9 of 2019, the Stonehaven School Incorporated request a special land use permit for the purpose of a private school in land lots 297 and 298 of the 17th district. The property is located on the west side of Old Concord Road, east of Pine Street, north of Cranefield Road. The Planning Commission recommends approval, subject to the following conditions. Site plan received by the zoning division on May 2nd, 2019, with the district commissioner approving minor modifications. Landscape and parking plan to be reviewed by staff at plan review with final approval by the district commissioner. Building elevations to be approved by the district commissioner. Fire department comments and recommendations. Stormwater Management Division comments and recommendations. Water and Sewer Division comments and recommendations. And Department of Transportation comments and recommendations. The applicant is present. Is there anyone here opposed to SLUP 9? Let the record show there's no one opposed. And moving into other business items on the consent agenda. Other business item number 45 of 2019 is to consider a stipulation and site plan amendment for GS Portfolio Holdings LLC regarding rezoning application Z41 of 2015 for property located on the south side of Cobb Parkway, west of Acres Mill Road, in land lots 912, 913, 948, and 949 of the 17th district. Staff recommends approval, subject to the following conditions. Proposed plans contained in the other business packet. Cobb DOT comments contained in the other business packet. And all previous stipulations not in conflict with this amendment to remain in effect. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to other business item number 45? Let the record show there's no one opposed. Other business item number 46 of 2019 is to consider a stipulation and site plan amendment for Five Guys Properties LLC regarding rezoning application 52 of 1988 for property located on the northern side of Roswell Road, east of Johnson Ferry Road, in land lots 829, 830, 899, and 900 of the 16th district. Staff recommends approval, subject to proposed plans contained in the other business packet. Landscape plan to be approved by the district commissioner, and all previous stipulations not in conflict with this amendment to remain in effect. The applicant is present. Is there anyone here opposed to other business item number 46? Let the record show there's no one opposed. Other business item number 47 of 2019 is to consider a reduction of minimum lot size for the Calvary Baptist Church of Smyrna Incorporated for property located on the south side of Windy Hill Road and on the north side of Belmont Avenue in land lot 519 of the 17th district. Staff recommends approval, subject to the site plan contained in the other business packet. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to other business item number 47? Let the record show there's no one opposed. Other business item number 48 of 2019 is to consider a reduction of minimum lot size and a reduction of public road frontage for proposed lots 1 and 2 for Rose Lane LLC for property located on the east side of Reed Road, south of Belmont Ave, and land lot 562 of the 17th district. Staff recommends approval, subject to site plan contained in the other business packet. Letter from Mr. Adam Rosen dated August 14, 2019, and Cobb DOT comments contained in the other business packet. The applicant's representative is present. Is there anyone here opposed to other business item number 48? Let the record show there's no one opposed. And combined with the two items added to consent for Commissioner Burrow, Z12 of 2019 and SLEP 7, as revised, that completes the consent agenda, Mr. Chairman and Board.
Commissioner Burrow?
I just have one more comment. On Z12, I'd like to thank Carol Brown with Canton Road Neighbors for working with the applicant on this and coming to an agreement with everyone. Thanks.
And I noticed that Mr. Rosen is one of the attorneys of record for one of the OBs, so this is your birthday gift, Mr. Rosen. Happy birthday. And with that, I make a motion to approve the consent agenda as revised. In discussion? Call the question? Passes 5-0. All right, first case, I believe, will be Z38, right?
Yes. Yes, sir. All those folks that were on consent, you're free to leave. Rezoning case Z38 of 2019, Joseph M. Thomas, Cynthia Aaron Thomas request rezoning from GC to NRC for the purpose of an auto repair facility in land lot 43, the 18th district. The property is located on the southeast corner of Dodgen Road and Veterans Memorial Highway. The applicant is present. Is there anyone here opposed to rezoning case Z38? Let the record show there's 2 people opposed. All those wishing to address the board, please come forward, be sworn in.
Okay, good morning.
Good morning, Commissioners. My name is Ellen Smith. I'm with Parker Poe. I have the pleasure this morning of representing the applicant with respect to this rezoning application. Just to give you very briefly a little bit of background, this property is at the corner of Veterans Memorial Highway and Dodgen Road. It is currently improved, and it has been for many years, many decades. It's zoned GC. It's about 7/10 of an acre, and the aerial gives you a little better sort of geographic view of where this property is. It has been used historically for light automotive repair, but it lost its grandfathered status as a GC use about 1.5 or 2 or 3 years ago, stopped being used for that light automotive repair. My client purchased the property a little more than a year ago. He has an existing business in Cobb County that is light automotive repair. When he bought the property, he wanted to expand that business to this property, necessitated rezoning to NRC. At the same time, and he was looking to reopen for light automotive repair. We spoke with Mapleton Improvement Coalition and understand that they prefer that this property not be used for light automotive repair. There is a car wash just to the left on your screen of the property. And forgive me, I don't have my directions in front of me, so I can't tell you if it's north, south, east, or west. But there's an existing car wash. Across Dodgen Road from us are a couple of warehouse-looking facilities. It's a frame shop, some other uses. All of the properties, or a couple of them next to us, are also zone GC surrounding this property. And to the south, or to the bottom of your screen, again, forgive me, I don't remember if it's north, south, east, or west, is an elementary school. So it is zoned residential, but not used for residential purposes. And actually, this school is slated to be closed next year as part of the Board of Education's ongoing processes. So just to orient you a little bit, there are existing commercial and other uses around this property. After we discussed this with the District Commissioner, Mapleton Improvement Coalition, we were going to come before you in July with a STIP letter that is of record. There's a STIP letter from July 10th, and Mapleton Improvement Coalition sent a letter in on July 12th that had a couple of additional conditions that we agreed to. As part of that, though, we started looking at it. The commissioner had some questions about a couple of the items, and we also discussed that this property, if it was rezoned to NRC, would be eligible for emissions and car wash. After that hearing, we understood, we didn't move forward. We requested continuance to address some of the concerns with respect to signage, landscape buffer, and use. My client agrees that there will be no automotive use of this property, even though that's what he bought it for, and agrees to add to that July 10th letter a prohibition that there will not be an emissions use or a car wash use. To make that change, however, he also needs some time before he puts in sidewalk along Dodgen Road, before he puts in sidewalk, curb, and gutter, which are all recommended conditions, and before he puts in some additional improvements to the building. And so we respectfully would submit to you that we agree to our July 10th stipulation letter, but with a few changes. I have hard copies that are redlined to show these to you that I can bring, but I wanted to just go through a couple of them. Again, to add in the additional prohibited uses. Both of the prohibited uses we understand Mapleton Improvement Coalition agrees with, and certainly you'll hear from them. But with respect to sidewalk, curb, and gutter, we respectfully request that we have a 6-month period after the issuance of a business license for a use on this property that complies with NRC, complies with the list of prohibited uses that we're agreeing to, but gives us time for an entrepreneur to do renovations to the interior of the building, to the exterior of the building, to install a dumpster with an enclosure per Cobb County standards, to spend that money to get aesthetic improvements that are immediate, but to have some time to defer sidewalk, curb, and gutter. Again, what we've proposed is 6 months after the issuance of the first business license. The same is true with respect to existing parking lot. There's existing parking on the property. It is sufficient to serve a light automotive use. It may not be sufficient to serve a new use. And so we're just asking for time again to be able to do sidewalk, curb, gutter, and paving, resurfacing, all at the same time for an efficiency of cost. We agree to any number of other conditions that are in the STIP letter. Just as I highlight also, one of the Mapleton Improvement guidelines that were codified into the zoning ordinance include a prohibition against any signage that's not monument signage. We actually agree to that, but there are signs on buildings around us that are building mounted or rooftop mounted signs. From a site distance perspective, we would respectfully request the flexibility to either have building mounted signage or to install monument signage, but to limit monument signage only to Dodgen Road and not on Veterans Memorial Highway, and otherwise in accordance with the sign ordinance. We also had initially included in our July 10th STIP letter a requirement to remove the existing loading dock. We are requesting that be deleted from the STIP letter because it's a drainage issue as much as a loading dock issue. If you remove the loading dock, it also impacts drainage for the property, and we'd like to leave that. It's also just a cost that is unbelievable to remove it. And also, Mapleton Improvement Coalition and the Planning Commission, which recommended approval at its hearing with a number of conditions, by the way, not limiting the property to the light automotive, or to prohibiting the use of light automotive, had required a fence along the property line between the building and the elementary school. But it was just one length of fence and seems to not really be appropriate. Number one, considering the historic use of the property has been for light automotive repair with the school operating for many years, and considering that the school is in fact closing. The Board of Education, I think, intends to continue some educational use, but with respect, if we're not making a heavy, intense use of the property that's light automotive repair or otherwise, it doesn't seem appropriate to have a fence just along one property line. With that, I'm happy to send in these or hand out these letters. I appreciate Mapleton Improvement Coalition's consideration of this application. Respectfully request your approval with these changes. Thank you.
Any questions? Okay, thank you. Those in opposition?
Good morning, Commissioners. My name is Sonia Wheatley. I'm with the Mableton Improvement Coalition. We often speak in front of you, and from time to time, I do think it's important to kind of bring it back. Like any civic organization that stands before you, it's not about me. It's not about Robin Meyer, who usually speaks. You're familiar with many of our board members who work across the county and in various faculties. You know, we represent a membership group. We operate a Facebook page, which brings interest with zoning cases. We hold meetings, we host meetings, we encourage meetings. So we're very engaged. It's not a Sonia Wheatley at Mick or Robin or just a couple of people. To this case specifically, I think he's pulling this up. We have been engaged in a long process of discussing this case and the use. This is a 50-year-old building that was right at or before zoning codes, and Mableton Corridor Study has been codified by this board. And the reason, just like all the other corridor studies, are to improve and bring into modern times and into modern safety standards the expectations that we all have today. It was operated as auto, and when we get it up, we'll see kind of the problem. A couple of statements about the location. It is absolutely true that the school to the south is being merged into another. Whether it, I'm sorry, one second. It's a PowerPoint. If that property is going to be reused or not, I don't know. It's my understanding from what lots of people involved with schools tell me that they often get reused. It does not negate the fact that to the north and to the right is a school that's going nowhere. The parcel on the corner, you know, it is about use, it is about appearance and meeting guidelines. It's also about safety. The entire length of this building is a driveway. And so there is no safe spot for the children who will continue to walk to the school to the north. All right, is that it? How do I move it? Okay. So this is what we're talking about, and this is from Google Images from times in the past. There is no sidewalk, there is no curb. I guess the building is 70, 100, I don't know how long it is. You can pull in and exit. There is no safety for elementary school children. Delaying this by 6 months and after a business permit means that for 6 months to a year, we are going to continue to have children walking across without any expectation of safety, any way to make sure. We hope everybody misses each other. There's no guarantee. This is the dock that we're talking about. We did ask the dock to be removed because the asphalt you see to the right is actually the school's property. The dock is on the property line. So whether we asked for a fence to separate, we just want a separation between this use, regardless of what it is. And we also know that most businesses, their back door is not the most attractive part. Even if it were to become a restaurant, I worked in that industry for 20 years. I don't think we need cooks and staff and dishwashers outside smoking adjacent to the kids that could be back in the school. So we would ask that that be removed. I don't understand the drainage concern. If there's curb, gutter, and sidewalk, it will go into the gutter. Again, a couple more shots showing, you know, just no safety path for anybody walking. We're saying children because there are a lot of children. There's a very large neighborhood down Dodgen. I kind of did a mock-up, just like in a rough attempt to say how would this work, and one of the reasons for being concerned about delaying this, you know, the asphalt, the parking, and the curb, gutter, and sidewalk is that it would be hard, I would think it would be difficult for a business that is open both to close and to plan what kind of use it could be when you don't know how many parking spaces you will have. If it's put in with the landscape strip and sidewalk, there will need, I'm told, I'm not the engineer, that there would need to be changes to parking. It would have to be angled in order to fit. But again, until that's done, we don't really know. So that's kind of a mock-up. What it was, right adjacent to the school. The only option, and are we expecting elementary and middle school children to cross two busy streets without any kind of safety so that they don't walk in front of a business who has more parking entrance, more driveway then the width of their building. This has been a rough process in that these letters have changed. As of the 10th, we were good. It was agreed no automotive, no emissions, no car wash. There was number 5 and 6 on the current. I've received revisions until this morning. We thought we were good July 10th, and then there have been 5, 6 iterations. This is out of the public view now, where we said we represent the public, and we're trying, when something's handed to us this morning, this does not get community input. We had people asking about this property, and we let them know that, we felt good. We thought we were in a good spot. It's hard to present that to the public. That's not what's on our website. That's not what I knew until, I think, about 8:45 this morning. So we ask you to approve the original July 10th with the addition of number 4 and 5 from today's marked up letter, making sure that auto uses are prohibited. And please require that this all be done before permits, before we have customers crossing, driving in, potentially putting children at risk. Thank you for your consideration.
Okay, thank you. Is there anyone else in opposition? Seeing none, Commissioner Cupid?
Thank you, Chairman. I appreciate the correspondence of the applicant and Mick and your efforts to work together to get to a closer agreement than what we had than what was originally filed. Here we have an NRC request for an area that's GC and that the GC status is no longer grandfathered. The applicant asked for a use that is allowable within NRC. However, there are overarching concerns in the area about the abundance of automotive uses along Veterans Memorial. And with communication with the community and with myself, the applicant acquiesced and decided to exclude all automotive uses. With that, they also had some concession from Mableton Improvement Coalition, which was to forego making modifications to the exterior of the building that are included in the design guidelines, but to add a monument sign to the roadway. And looking at this property, a monument sign off of Veterans Memorial looked questionable to me because it's so close to Dodgen Road. I had concerns about visibility and also it being so far away from the used portion of the property. Having a monument sign off of Dodgen Road also didn't make sense to me because it's just a 2-lane, primarily residential road. You can't see that from here. But you pull back, it's primarily residential, and there's no other monument sign. So I do support there being some flexibility on the signage. Also, you could see from pictures provided, this is an old metal building, and the applicant actually has another site off of South Cobb Drive, which is a metal building, but it's painted very well. It looks sharp, it looks crisp, and it has signage on it, and that signage kind of makes the colors on that building pop. And because this building needs some help, I'm thinking that if it was painted similarly to that other building and the signage was erected on the side, it could make what looks to be a very tough-looking building better. So I am supportive of maintaining that stipulation where there's flexibility on the signage. What I am thinking is the greater concern has to do with providing a 6-month time frame to allow the owner or the new business occupant to be able to make some changes to paving and improve paving or resurfacing the property, and also for them to add sidewalk, curb, and gutter. Considering that the current owner and applicant's business, which is allowable under NRC, will not move forward out of their work with their community, and that any other NRC use is likely to be less intense than an automotive use, and also considering that sidewalk is very expensive. Just to add curb and gutter and sidewalk, you're looking at a $1.5 million expense. I am willing to wait until someone comes in and has the resources to be able to put in a sidewalk. Because I think if you just saddle someone who could come here to this facility and put, for them to put that in prior to starting their business, we're already killing that business's opportunity to be viable, particularly a business that's going to move into this type of location. And me, please understand, I consider myself to be the sidewalk queen of Cobb County. I'm favorable of sidewalks, but I also, pardon me? Oh, that's you too? Are we the queens of sidewalks? But, you know, I know they're needed, but I also know from walking this area, unfortunately, we had an accident off of Veterans Memorial. There are sidewalks right across the street here and that lead out to the intersection of Veterans Memorial. So in the meanwhile, while the applicant has the ability to weigh whether or not they're installing sidewalks, there are other sidewalks that can be accessed on Dodgen Road. And I think working with DOT 6 months after moving in gives them opportunity to be able to see how they can still get them installed, but make it to make it reasonable. And you see where the hand is on the screen. That's where the sidewalk would connect to. Give me one moment while I look at some of these changes. There have been changes that have been going on, yes, as late as last night. I'm not aware of any from this morning, but the changes have been on both sides. So there have been additional restrictions that have been added by Mableton Improvement Coalition that I did not receive until like 2 days ago regarding emissions in car washes. And then there have been some changes by the applicant, and that's just the nature of negotiation. Now, I mean, I could continue to hold, I can hold this if you want to continue to talk more, if you don't think it was fair to have that, to have those last minute changes, but it's not just on the applicant. It was, again, it's from the community and it's also from the applicant, and that's to me just the positive nature of zoning. You want to encourage and facilitate people working together. And I believe that the additional protections that Mableton Improvement Coalition can receive by adding in additional automotive uses that will be restricted is a positive thing. But I also think considering the significant limitation that this applicant that works in the automotive business is making to this applicant, I think it's only fair to be accommodating to who could be the new applicant to allow some of these other changes that have been submitted. There was a picture, and I don't know if it's still up here. Sonia, you had a PowerPoint that showed the loading dock. And certainly you can see the side setback. There has to be a variance there. With the school closing and not knowing that use, and with the school not putting in that fencing, and knowing that the use of this building will be less intense than the automotive use, I'm not necessarily wedded to putting in a fence right there. And if the fence is going to be on the property line, then now I have to be concerned about us encroaching on the school property as well, if they were to add a fence and add a buffer there. So, you know, if that loading dock was removed, certainly I would like for the applicant to consider putting a buffer there. But again, I'm just looking at this very old building that, I mean, even this paint color that's on there now looks better than how I've seen this building look. This building has looked run down to the point where I thought a fire had taken place in there. But I think over time, as someone comes in here and has the ability to be profitable, yes, I would like for that to be considered. But for right now, again, knowing that that school is not going to be in existence or operating within a year, I don't want to put that onerous expense that could limit us moving this building forward. So with that, I ask that we do approve Z38 to NRC, subject to the Planning Commission comments and recommendations, but also subject to the markup letter dated July 10th that was provided to commissioners and staff today, with any conflicts with this letter and the PC recommendations being superseded by the conditions here in this letter. And let me just, make one cursory view. Yes, that's my recommendation, also to include other staff comments and recommendations not otherwise in conflict.
Okay, we have a second?
A second.
Comments?
Question.
Sure.
Sure.
Is there any landscaping that could be done on that in front of that concrete,
It's just right in front.
or is it
Facing
on the right of
VMH.
way or school property?
There could be, well, if I can get I don't know if you have the building side. There could be on Dodgen. If you see that dock, it's right on the line and it actually is off the property line. Part of that is off the property
Kind
line.
of referring to where the dock is, that concrete slab in front of
Yes.
the dock.
To the, fr-
Can you go back to that other picture that was on, of the dock?
Yeah, but you'd have
It
to,
may not be on this,
there was a picture that showed the front elevation of the
you
building.
just had it before the, right.
Mhm.
Any trees that could be planted at that
Yeah.
end of that slab?
Yeah, I think that's a good recommendation. It will discourage actually use of that dock from a vehicle driving on there, which doesn't look good. But yes, we can have an applicant if you could. Yes, please.
is that school property though,
Well,
or
that's what I was,
is that,
Unfortunately, it looks like it is.
I think it's school property.
He's right. You see that area that
That's
dips
school
underneath?
property,
Right.
but there is a condition that requires us to remove the paving that is on the school board property. But it literally goes up to where the loading dock starts. So with respect,
Can you
just
point
just
that
so
out? Can you
you,
point that
I
out,
don't know if
Ellen?
you can see it on the tax map. If you could.
Commissioner Cupid, while she's
Yes,
pulling
sir.
that up, Ellen is saying that they've agreed to pull up the asphalt. Have they also agreed to sod it?
Sod.
Well, because, I mean, are you pulling it up and leaving it gravel or dirt, or are they gonna put grass?
They're
It-
supposed to
it
resurface.
Requires that we remove the pavement that's on the school board property and sod it.
Okay,
Oh, you're talking about the school board?
Yeah, I'm talking about the
I'm
school
sorry, I thought
property,
you were talking
yeah.
about the others.
that part right there.
Okay.
That's right.
so that whole slab is school property,
Correct. It's
up to where that car is parked on the dock?
correct.
Okay. And then that and sodding, but I still.
So that's condition 2F.
So not, since you don't want to put a fence, and I understand the reasoning behind that, I still think a row of trees on that side on Dodgen kind of puts a little buffer between them and the school, but
I don't think we object to it. It's school board property.
once you remove the slab, that's,
Correct.
you're, okay, you don't have any
Correct.
wiggle room there, okay.
Okay.
Well, okay.
Commissioner
I
Campbell?
just have one question for clarification.
I'm sorry, and the only other thing I would say is, whatever use is acceptable under NRC is still coming back to you for approval?
I didn't do that, but I could add that. That would be helpful, but the list is quite exhaustive, to be
Okay.
honest.
That's up to you, I just,
Yeah,
normally
don't-
we do that.
I don't necessarily think so. We have 15, 16,
We
about
have
17,
listed
18, yeah, we have probably about a list of 20 prohibited uses. But thank you for that consideration.
Commissioner Campbell?
Just for clarification, the timeline for the sidewalks? to be
6
done?
months.
Okay, I wasn't sure if you were gonna change that.
Yeah, we had 2 years, and then there was some concern with the community. I can understand the paving. Sidewalks, again, it is an onerous expense. There was a facility that was coming in to put a veterinarian's hospital on Mapleton Parkway, very much supported by the Mapleton Improvement Coalition, and they asked for something similar because they just could not afford that expense when they came in, and it was reasonable, especially considering that sidewalks expenses are very high. But I want to be sensitive to the concerns of the community, but I just know realistically, sidewalks are very expensive in it. What I hate is to set someone up for code enforcement, right? If I say 6 months after the business license and it's not put in there, what's gonna happen is the district commissioner is just gonna end up getting notices of violation about this. That's just what's gonna happen.
Okay.
Trying to think of so, because we got to the 6 months, and trust me, it took a long time to get there, we'll keep that. In fact, if an applicant wants to come in and they need a longer period, we'll look at other business again to change that condition. But thank you for asking the question.
Okay, with that, I'll call the question. Passes 5-0. Okay, LUP 16.
Yes, sir. Land use permit number 16, Ricky McCravy requests a land use permit for the purpose of allowing more unrelated adults than the county code permits in land lot 1223 of the 19th district. The property is located on the south side of Luther Drive, east of Center Place. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to LUP 16? Let the record show there's no one opposed. Would the applicant please come forward and be sworn in?
Oh, no.
That's what they were recommended denial.
Did you read?
They recommended, the PC recommended denial and staff did, that's why. Sorry?
My name is Ricky McCravy.
Morning, sir.
And the house that is in question is, has been, had the same situation for about 30 years. I'm not going to go down the road of explaining everything right now unless you guys really want me to. It sounds like no matter which way I go, it's not going to be approved. So I would like to, and by the way, just a note, there is a duplex about 11 houses up the road inside of this subdivision. And there are a couple of houses that are doing the exact same thing in the neighborhood. But me and my wife would really like to have time to sell the house. This is a house that I grew up in, but because of the situation, we inherited. And I would honestly just like to be able to have time to sell the house. We're in the process of selling another house that I really need to sell first. But anyway, that's a request I would like to make.
Could you explain the circumstances? You said this has been this way for 30 years?
Yes, sir.
The number of occupants has been that high for 30 years roughly?
Roughly,
What are the
yes.
circumstances for that? I mean, even I'm curious.
Sure. It started off, like I said, about 30 years ago. My mom was friends with the neighbors, and one of the neighbors was getting a job out of state, and they needed to sell their house, and they sold it. They moved in with us. It's a two-story. It was a 2 stories, and they moved in part of that house. And so that lasted for probably, I don't know, 8 months, a year or so. And then there was another family down the road that right after that, their house burnt down, and my mom allowed them to come move in to the house while their house was being rebuilt. And then after that, she continued to rent the house out. She needed the income, and that's just what she did.
Okay.
So I left that house probably for about 7 or 8 years. I got married, moved away. She got sick. We moved back in to help take care of her, and then so we've been there ever since. So that's a 30 years span of all that.
So who's in the house now?
Me and my wife.
Okay.
We leased part of the house out to an older lady and her grandchild, and then another older lady we rented to, and she moved her adult daughter in with her, and that's the way it is right now.
Okay, all right, thank you. I appreciate you clearing that up for us.
Yeah, thank you.
Okay. Any other questions from the board? Commissioner Cupid?
Yes, thank you. According to staff comments, the home is big enough to permit even more people than are living there, but because the persons in the home are unrelated, you're coming in for violation of our code. And staff, in fact, provides that if you were allowed to exist as you're currently functioning, that you would meet the requirements of a rooming house and would be required to meet additional fire code to allow the existing use to continue. Allowing that type of use to continue in a single-family residential area is just out of character for that area, which I think you understand. I do appreciate the chairman's questions, asking you who's in the home, because I want to be mindful of that. And if there's a grandchild living there, I presume, I see you not, is the grandchild of school age? Okay, so I do not want to permit this land use permit, but what I would like to do is delay its enforcement until the end of the school year so that, that family does not have to pick up and move. And regardless of if we deny the permit today, or if you still have the flexibility to sell your home, What we want to do is make sure that you have a use that comports with current code. So what I'd like to do is deny land use permits, I move to deny land use permit 16, however, permitting the applicant to have a grace period until the end of the calendar year for the residents of this site to be relocated to end of the school, not the school year. I was actually going to do the calendar year. And I'm unwilling to wait till the school year, only because this has come in as a code enforcement complaint, and I know it's not.
So why don't you stay with the school year? Because moving in December
Do
is,
you think, are you
oh,
open to
yeah, I'm
waiting
fine
till
with the school
May?
year. Sure, absolutely. It's
Okay.
compassionate. Yeah, sure.
Okay.
Yeah.
Okay, just know we're gonna continue to get code enforcement concerns, and just know that there are residents living here that are
Well, we'll just send
frustrated
them
with
to
the
the
use.
appropriate district commissioner that's responsible for code enforcement.
That would be me.
Oh, I'm
They'll be
sorry.
contacting me.
Perfect.
But again, being mindful of your situation, and I appreciate the sensitivity of the board, and hopefully this will provide you sufficient time to market your property. I will ask that we delay enforcement of land use permit 16 until the end of the school year. And that is my motion.
Okay, we have a second?
Second.
Discussion, comment? Yes?
Just one other comment. They are allowed, he and his wife and one other unrelated.
Yes.
I know that doesn't help the situation with 6 now, but in the future, they could just have one unrelated with he and his wife,
That is true, that could be permitted.
just to let him know.
Okay, all right, other comments?
No, I know I'm gonna get
I'm gonna call a
contacted.
question before you rethink it.
Okay.
I am. Passes 5-0. I hope that helps you, Mr. McCravy. Okay, let's, one last, what's OB 49 now for Commissioner.
Yes, sir.
Gifford, yes.
Other business number 49 is to consider a stipulation amendment for Meritage Homes of Georgia Incorporated regarding rezoning application Z44 of 2017 for property located at the southwest intersection of Lloyd Road and Glore Road and at the northern terminus of Green Valley Road in land lots 29 and 30 of the 17th district and 1073 and 1074 of the 19th district. By way of background, the subject property was rezoned to the Planned Residential Development Zoning District, PRD, in 2017 for a residential community. As part of the approval process, the board adopted the Planning Commission minutes, which required all front elevations, including single-family residences, townhomes, and bungalows, to have a minimum of 50% brick or stacked stone. The applicant would like to amend the stipulation to allow other materials such as shake-type siding, board and batten, hardy plank, or other materials that the applicant may discuss here in a moment. If approved, all stipulations not in conflict with this amendment should remain in effect. The staff would ask the Board of Commissioners to conduct a public hearing and consider the proposed stipulation amendment. The applicant is present. Is there anyone here opposed to other business number 49? No one opposed, but someone's probably concerned. All right, okay.
Okay, well, let's, all right, we're gonna have Mr. Rosen come up and present his case, and then those who want to make comments after that can do so, all right?
Thank you, Mr. Chairman and Board. Adam Rosen with Sam's Lark and Huff and Valley here this morning on behalf of Meritage Homes of Georgia. Thank you for the early birthday present. I hope that's not the only one that I can have for today.
How long you talk?
It's my mother-in-law's birthday today too, so maybe we can have a birthday present for her. As Mr. Peterson pointed out, this is an application to amend primarily the 50% brick or stone requirement for the zoning that was approved at the end of 2017. Generally, the concept for that approval had three different types of homes: detached homes, townhomes, and bungalows. It required district commissioner approval. It required the 50% brick or stone. I think the shortest answer is that going through the elevations that Meritage submitted for district commissioner approval, I will say that we started off on a bad foot, and I think that we hopefully have spent a lot of time. We have spent a lot of time, but hopefully during that time have corrected that the best we can. But what happened in that process was submission of 50% elevations and those that weren't. And going through those, I think the product of what is Exhibit B in the stipulation letter that we're asking you to approve today, that we believe are those that are favored after meeting with the community and your district commissioner. And by the way, we wanted to go to Mableton Improvement Coalition early, even though they weren't a mandatory part of this process, because we understand that your district commissioner does care about their input and what the community's input is, because this is an important piece of property for the district. What Exhibit B is a combination of those that actually do meet the 50% requirement and some that don't. And so we realized that those couldn't be approved without a condition change. The only other change to the application that's in my stipulation letter of August 14th is to add a 20% limitation to single-story homes. And that's not an architectural percentage, that's the number of single-story homes that can be in the single-family detached area. And that's to make sure we've got a good mixture of products for families and all of the different demographics for this area. Other than that, this is strictly a 50% brick or stone requirement change. What we're asking you to do today is to remove that, but when you're removing that, you're approving specific elevations. So you're not leaving this open to what's to be for the future for the single-family homes and for the townhomes. We are asking you to allow the bungalow homes to be approved, unless I hear something different this morning, to be approved later. Mableton Improvement Coalition's recommendation today is for those to be approved through another business item. If that is the only path forward this morning, we will work with that process. Our recommendation would be to leave that up to your district commissioner. We will volunteer to go back through Mableton Improvement Coalition with comment and review and to attend another community meeting if that helps give the public process. But I think their recommendation as it stands now is to come back through other business. And at this point, our priority is to get some homes approved so they can start building. This property's been site developed for a long time, and it's time to move forward. So that's about as short as I can make it. These are the elevations that have been presented. This is an example of why we want to get rid of the 50%, because there are some that were just not liked because it was just an attempt to meet the requirement. This is one that was approved with no brick or stone, that part of the stipulation letter, so you've got some precedent for it. I'd be happy to answer any questions. Meritage Homes is here with us this morning, and we thank you for your time. Commissioner, thank you for your time. I know you like to have a month break from me, and we appreciate you working with us as much as you have, and Mableton Improvement Coalition. So we're here to answer any questions. Thank you.
Thank you, Mr. Rosen. Okay, those who want to make following comments?
Thank you, commissioners. I know that there is a tight timeline. I don't even think I need to pull that up. I think we're in agreement, the ones that on everything except the bungalows. We do request that you come back with another that they come back with another business item for the bungalows. This has been a very long process. I mean, we are currently almost 2 years out to getting this, approved elevations. To be blunt, it's just, the most important thing is what's on Floyd Road. What was approved in December of 2017 doesn't look anything like anything we've seen right now. I actually did it, but you guys are in a hurry today, so I want to be respectful. If you watch the video from December of 2017, what is on the screen, what is presented, the renderings don't match. So we want to make sure we're clear that there are changes, that what's approved is what the community expected and what we supported in 2017. That's it. Thank you.
Thank you. Any other voices?
Good morning.
I'm
My
sorry,
name's-
sir, were you sworn in?
Pardon?
Were you sworn in?
Yes.
Okay, all right. then, okay.
Yes. Good morning. My name is William Barnes, and I am the HOA president of Bloor Crossings 2 Homeowners Association. I don't really feel that the homes are, well, I feel that the homes are going to be adequate and acceptable in my mind. My only feeling is the lights that was supposed to be installed on Floyd Road and Bloor Road, I understand it's not going to happen. And that was my big concern.
Okay.
Because I called the DOT and they said that there wasn't adequate enough traffic to
Oh,
put a light
yes,
there.
yes. Yes, this was a significant discussion with the board, and I know I followed up with DOT about us meeting metrics on there as far as traffic is concerned, we still have not been met, but we had a robust discussion, if you can remember,
Right, yeah.
commissioners, about this matter. I don't want to speak on behalf of DOT, but if DOT can address their consideration of that, please.
Because I thought we were going to be proactive and not wait till something happens. That was my,
Yeah, I remember this discussion. I'm not sure why it is I thought we were gonna put a light there.
Are you supportive of it?
Yes. That was the thing that we were gonna, for once, we were gonna get in front of a problem instead of reacting to a problem.
Amy Diaz, DOT. You're fine?
Yes, ma'am.
Okay.
I think there's support amongst commissioners for a traffic light to be here. It was a robust part of our discussion. You can go ahead and share your evaluation of the light there.
As of the last time that the signal warrants were checked at this location, it did not meet the warrants for signalization.
Right. That was your message last
That's the
time.
DOT.
Right.
Right, but I think the last time we talked about this, and we continue to treat these warrants as absolute requirements and absolutes, and they are recommendations. And we've had this discussion before, and yes, I know that the beige book, you have to meet warrants, but I think that the issue is that we are basically told that these are, you have to meet these warrants. That's not true. It is recommendations. And I think that, let me finish. And I think that DOT needs to, when they want to make a recommendation because it doesn't meet warrants, it needs to be presented like that, instead of being presented that it doesn't meet warrants and it can't be done.
It can't versus.
And it's, because we've gone down this path before numerous times, and we keep being told it doesn't meet warrants. Okay, it doesn't meet warrants, but if the board decides they want to put it in, and DOT cannot say that it's an absolute safety issue by putting it in, I think that's what needs to come out instead of just coming up here and saying it doesn't meet warrants.
If we went back, if you could watch the video from last time, we made it
Okay.
very clear there was gonna be a light put here.
Then with the board support, I will follow up and see how that could be done. That's not related to this other business item, but I appreciate you coming forward to get that clarification up here as we discuss this case. Thank you,
No
appreciate it.
problem.
Okay.
No. So I will, we have to, wait for John's recommendation.
You can get it.
Mr. Chairman of the board, the staff would recommend the board deny this request.
Because
It's staff's belief that what was approved in 2017 would result in a better product that would stand the test of time. I spent a lot of my time bringing architecture to each district commissioner, and the one thing that each of them instills me every time is they want a higher standard of architecture than the last person who came in. And Commissioner Cupid and I have spent many times talking about houses that have been built that don't stand up to the architecture that was shown at the hearing. So staff believes that if you leave the architecture the way it is, the county's gonna end up with a better product.
Okay, thank you. Commissioner Cupid?
No.
John, I appreciate this level of support. We have been on this, we have been down this road for like 2 years, going back and forth with elevations. We did have elevations provided that had more brick and stone combinations, but it was so busy, and the community and me, we could not support some of those other elevations. The elevations that are of greater concern that were shared in the agenda item and are not being brought forward today were the bungalows. And I support Sonia's request that those bungalows come back, because what you saw in the packet was not what was brought forward to the community. However, the elevations that were in the packet that were not 50% brick and stone in the original application, that's supported by some of these. The PC recommendation shared that they would be 50% brick or stone, but again, that application itself and the pictures provided had renderings that were supported by the community that were not 50% brick and stone. So I'm hoping that we will see a better product that's that the community can support for the bungalows when that comes back in for other business. But considering the hours, and the community and myself, we have spent hours late up at night going over these. I just think there's adequate support for these to move forward. But I do appreciate you being supportive of us moving the elevations in the district forward so that they do stand the test of time. I really appreciate that.
I just have a comment too, on some of the developments that were approved by this board in the Wildwood office complex. The test of time showed, for example, when everybody thought that stack flats was going to be a great idea instead of vertical townhomes, and it turned out that they were not. They didn't sell, and there was a lot of complaints about noise and things like that. So I do think that over time, sometimes things that are initially proposed, it kind of shows, especially with the amount of time you spend on this, that it's not going to work. But I think where you're to be commended, okay, is the fact that the community is not all of a sudden finding out after the fact when something different is built than what they thought. Instead, you have it brought back here as another business item for the community to see and comment on. So it's a little bit different when the community doesn't get what they were promised, but they find out after it's built, versus how you're doing it now, where here it is at hearing in front of the board and the community, and Mick had an opportunity to comment on it. So I think you're to be commended on doing it that way.
Thank you, appreciate it. So with that, I support moving forward with other business item 49. There is some question about two particular elevations, which were Jackson E, and then there's a Presley C. Oh, Lord, I'm sorry, I was packing up my belongings, Adam, and I don't have those two numbers. But just ask for, do you have those two letters before you, Adam? Can you share that with me so I can put it on the record? No, they're not in the bungalows. Thank you. Oh, I have. Let's see.
Commissioner, the two that I believe you're referring to are the Jackson C and the Presley E.
Yes.
And so that we can offer that home, we'd like at least the opportunity to work on color schemes and things with you on those.
Okay, so I would just ask that we work on getting a different mix of colors for those two elevations prior to those being built. So if those were to come forward for permitting, that those would come by my desk for me to review.
We're agreeable with that. Thank you.
Thank you.
Okay, we have a second
Second.
discussion.
You want the bungalows to come
The
back?
bungalows will come back for other business item. Thank you.
Okay, any comments? Call the question. Passes 5-0.
Thank you, guys. I really appreciate it.
Happy birthday
Happy birthday, Adam. You got
for your mother-in-law. Make sure your mother-in-law knows this is hers. All right? I don't want you, no Indian giving here, Adam. All right, now we're going on to Z24.
Correct.
Mr. Chairman, before we start.
Sure.
And John and I talked about this. The applicant is going to come up and only tell the board what's different, because when they left at the last meeting, we asked Parks to come back because there's a question, this is the one with the question about the deed and recorded lot lines.
Right.
And so when the opposition comes up, I would like to remind them that we only need to hear something that's different from last time, because what you said last time is already on the record. Parks is under the same instructions that this is to talk about what's different and new. The board doesn't need to hear the same thing over again.
Okay. You okay with that?
I'm okay with that.
Okay, all right, you have the floor.
Okay, hold on, 1 second. Rezoning case Z24 of 2019, Cheryl Upshaw Family Trust, request rezoning from R20 and 09 to R15 for the purpose of a single-family house in land lot 816 of the 17th district. The property is located on the eastern side of Ridgewood Drive and on the west side of I-285. The applicant is present. Is there anyone here opposed to rezoning case Z24?
Okay. No, during your comments.
And let the record shows there's 3 people opposed. All those wishing to address the board, please come forward to be sworn in. 4? Okay, just let the record. 5? Okay. Let the record show there's 5 people opposed.
Okay?
Good morning. For the record,
Morning.
my name is Park Suffer, the law firm of Sam's Larkin Huff and Valley, and I represent the applicant in regards to this case before you this morning. I'll be brief and only touch on the differences from last time. This case, was a staff recommendation for approval, planning commission recommendation for approval, comes to you as a site, as a lot that is a subdivided lot in Cobb County, Zone O and I, in a residential neighborhood. So this is the lot here. This is a subdivision plat book 278, page 411, that was filed on behalf of the applicant by the surveyor, this plat, and then their corresponding deed that is in my client's. Just put that up there, that it's in the record, is matches the legal description of the property that she was deeded, several months ago prior to this application being filed. And so that's the confirmation that the lot is a subdivided lot in Cobb County. It was subdivided pursuant to an old plat that had some vagueness to it, with some right-of-way being taken by I-285. It has always been 2 lots in this area, and the surveyor has certified via filing the plat in the plat book of Cobb County that is in fact a subdivided lot, as mentioned before, Zone O and I. So you can't just leave a commercial lot zoned commercially in a residential neighborhood. This is consistent with other things that have happened in the neighborhood in terms of existing lots being zoned appropriately and allowing homes to be built on those prior existing lots. So that's the change. That was the information that Commissioner Ott requested last time, that we certified that that lot is in fact a certified subdivided lot. Surveyor has done that. It's subdivided in the Cobb County real estate records, consistent with the original plat and the new plat that's filed here. And the legal description matches that. Thank you.
Okay, thank you, sir. Anyone else in support? Okay, now the gentleman had a question. If you come up, please.
Yes, sir.
I'm a little confused by the stipulation because we have not presented this to the board. We presented it to the planning board, but not to the Board of Commissioners, so I'm a little,
John, I thought when we talked about this, we said that we had, and I may be confusing with the fact that I had a meeting with both sides.
Yeah, I'm looking back here at the history of it. It was held by the Planning Commission in June, and then it was continued by the Board of Commissioners July and August.
Right.
Yeah, so if we didn't have a hearing, then yes, I apologize. We had a meeting. You did such a good job in the meeting. I thought you had presented it here at a case.
yes, sir. Well, so I don't know now what to try to do, to present it as we were planning on doing, as we did to the commissioners, or can we do that, or?
Yes.
Look,
Thank you, because-
what I don't want to do, all right, is dilute your presentation where it has an impact on your argument.
Yes,
So
sir.
you do what you think is necessary
All
to
right,
make your case, okay?
Thank you, sir, appreciate it. Sorry for the confusion.
No, that's fine.
And sir, if I may,
It was a shock to me.
there's a timer right beside you. You have 10 minutes to present your case. We're starting
Thank
the
you very
timer at this
much.
point then, okay?
Good morning. My name is John Patton. I am a homeowner and a resident, have been for almost 40 years of this subdivision. I'm also the executive of Mom's Estate, which owns a house directly across from the requested rezoning. It's predominantly an R20 subdivision. The covenants required an absolute minimum of 16,000 square foot. Granted, there have been some exceptions to that in this area, but none of them of this small a lot. And I'll get to that in just a moment. Basically, there was a subdivision that was platted before the house in this area was built. I-285 came along and cut off the back of those lots. 5 years later, the developer sold 2 lots in this transaction together as one transaction. Basically, we're talking about 55 years ago, all this happened, and the developer was compensated for the loss of that property to 285. The home at 3899 Ridgewood Drive was built on 2 lots. It has been said that it was just the drive, but in fact, a portion of that lot, as I will show you, was that house was on both lots. So this is a Cobb County easement map, and if you will notice very closely, the house shown here, that old lot line bisects that house on that easement line. This, if I got it right. This is the plot plan that was developed for citing of this in the same conjunction with the closure and the deed that was shown recently. And if you will see, the corner of that house is cut off by this lot where it was combined with this lot originally. There were some issues about the tax map. There, in fact, was some apparent movement of the line between these 2 parcels or these 2 lots. They did remain to be 2 parcels, but there was nothing definitive that explained the apparent movement of those lines. And in fact, the dimensions didn't change on those lots, except in the last version before this lot was sold, the dimension was erased. Nobody knows why. To me, that doesn't mean a whole lot. The house was designed, as was put forth in the Planning Commission, specifically to meet this lot. But if you will notice on this map, even down in here, it talks about a variance being required, all of the offsets, everything is based on the assumption that this will be rezoned to R15 with a whole bunch of variances. We believe that this is out of character of the neighborhood. I also like to point out here
there was a lot made of the fact that these two parcels were on the tax map and that line apparently moved. But if you will notice, pardon me, this is the survey that was done with the easement for the driveway. We're talking about less than a quarter of an acre a lot in an area that is predominantly R20. And they even had to cut an easement to the existing house out of that less than a quarter of an acre lot in order to make it less than a quarter of an acre. So in the process of that easement being done, in conjunction with the closing on the sale of this property, if you will notice here, it stipulates that the frontage of this lot is different than the tax map, where I have pointed out there. The point I'm trying to make here, this lot did not exist before. It was cut out of whole cloth. It was created by this surveyor. Now, if you could have a surveyor come out here and say, okay, I'm gonna create a new lot with this survey, and have a lawyer write it, that the dimensions of that new lot into a deed, then can I divide my lot into, can I divide my 1 acre into 4 quarter-acre lots and come here and say, here, I've got a surveyor that created a new lot, would you please allow me to build a house on it? And I think zoning has to mean something, and I don't think that I should be able to do that, and I don't think that these people should be allowed to do it either. There, in fact, have been a few adjacent properties that were zoned R15, but all of them are at least 15% larger than this piece of property. All of them have 100 to 200 foot of road frontage as opposed to the less than 75 foot of road frontage that was cut out by the surveyor in this. I believe that due to the size of the property and the boundary line movement without any documentation other than at the time of selling of this property, that approval of this application would create a bad precedent. I therefore request disapproval of the application. If there is any hardship, I believe it to be on the neighbors if this is allowed to go forward, not on the person who apparently, in my opinion, purchased the property knowingly speculating that a zoning variance and rezoning issues would be resolved in their favor. I thank you very much. My neighbor would be next.
Ma'am, of the 10 minutes, you have 3 minutes and 26 seconds. It's right there on your camera.
Good morning. I'm Melody Johnson, and I am the owner of the property that is north, adjacent to the subject property that is asking for the rezoning. And when I purchased my property, it was a similar situation. And the information from my seller was conveyed to me that the lots that I purchased had to be combined in order to have one property built there, because if not, the two parcels that she originally owned were not large enough to build two structures or to sell that property in that manner. And if you subdivide my lot, which was originally subdivided, it is greater in square footage than the 10,200 square foot lot that is being proposed to build south adjacent to me as well. And I do have a picture of show that picture, of the proposed area where we're looking to rezone the small 10,000 square foot parcel there, and the easement where the driveway is positioned. And I also want to say that I have several neighbors that could not be here today that are in opposition, and I would like to also be the voice for them. I have their letters. It's over 20-some neighbors that are in opposition but could not be here. So I won't read the letter, but I would like to submit the letter to you all so you can actually have it on record. Thank you.
Okay, thank you, ma'am. Any other voices in opposition? Seeing none, Commissioner Ott.
All right, so let's, excuse me, Bill. The main reason that this was continued, and sir, I apologize, like I said, y'all did such a great job when you came to talk to me. In my mind, we had a presentation, so. The issue, the reason we held this last month was there was the question that the opposition brought up about the validity of the lot. And so what staff and county attorney office and everything said that we needed to have was something, a recorded deed, recorded warranty deed or whatever that showed that the lot truly existed. That is what was submitted by Mr. Huff. So, Bill, based on that, this is indeed something that we can hear, correct?
Yes, it's something you can hear, and it's also something that you can rely upon. It's reasonable for you to do that.
Right, and if the opposition has an issue with, you know, whether or not how this was recorded and everything, that's really a civil issue. That's not something in front of this board, correct?
I wouldn't be able to advise them on what they would need to do, but as the board would be able to rely upon it, yes.
Okay, all right, so the situation is we have a substandard lot. By that, I mean smaller than what is it's zoned. I mean, currently it's zoned R20 and O&I.
Yeah.
All right, it's only 10,000 square feet. So even if the property owner wanted to build a house and not rezone it, they would be in front of this board because it's a substandard lot. Because they cannot build an R20 house with the R20 setbacks on 10,000 square feet. So they would be in front of this board asking for variances to build on the property. They would also not be able to build a residential house because a portion of it is zoned O&I. So one way or the other, this piece of property was coming in front of this board. And this board cannot deny someone the use of their property. We would have to buy it. So this is one of those situations where it's not ideal, but, and yes, it's smaller. And I know this situation is a little bit different than the lady from opposition stood up and said about joining her two lots because she happened to own both of the lots. That's not the case here. This is a legal lot based on the information that's in front of the board. So it's all similar when we get a general commercial lot that's lost its grandfather status. We have to do something with this lot. And so, you know, the variances, I know we typically don't like to have variances. There's gonna be variances on this lot no matter what's built on it. So I'm less concerned about the variances for the setbacks, especially the rear one, because the property was made smaller as a result of the interstate. Parks, you didn't get your full 10 minutes, so do you have the elevations for the house? Oh, I know, but
That's the elevation, however, and this was designed by Frank Betts, a well-known architect. The height is compliant with the zoning height. We're not asking for height variance. However, it was noted at the planning commission level that the height was, you know, you got to be careful and make sure it was done correctly. Otherwise, you're going to be right up against it. So my client has agreed to remove the top floor.
right, that's why I wanted to see the picture, so I thought that's what, when I met with you all, that's what I thought you had said. So it's actually doesn't have that top
Correct.
floor, right? Okay.
Even with it, it technically would meet it.
Right.
But it would be close to, there was cautionary note at the planning commission when they recommended approval that we look at that, and my client has agreed to remove that top level.
Okay, thanks. I think before I make a motion, I'd like to hear other commissioner comments. This is not an easy case to look at. I mean, it is confusing. There are, as the opposition mentioned, there are some issues or questions about the lot, but, you know, as county attorney or soon-to-be county attorney stated, it is has to be considered as a legal lot by the board.
I have a couple comments.
Sure, go ahead.
Well, one thing is good that it is just under the impervious surface limit, which is a positive, because that's the first thing I look at. And I understand that the issue with it being zoned R15, but only having 10,228 square feet, so there's no way to get a straight R15 with 15,000 square feet. Can you go back to the GIS with the outline of the parcel? Okay, this O and I, just that little sliver on the left, is that what's O and I on this whole lot?
No, pretty much the whole lot's O and I.
Yeah, actually, the only part that's, here, put it back, the only part that's R20 is the little sliver along the Ridgewood Drive. So the reality is
okay.
you have probably
you.
9,000 some odd square feet of this lot,
It's
which is
O&I.
O&I in a residential
In an
neighborhood.
R15,
So it's even more compelling that it needs to be zoned to a residential category.
yeah.
And so if you zoned it to R20, and you see the rest of the neighborhood on that side is R15, R20 across the street. If you zone it to R20, you're actually deviating from the required lot size by a greater amount than if you're going to R15. But with the fact that it's O&I, and the reason it's O&I is prior to the putting Interstate 285 in there, and I know, sir, you've lived there longer, there was another road that kind of went on the other side of these properties, wasn't there? I think on the old Parks, do you have, I know one of you guys showed me a slide that showed what was there
Go
prior
the
to the
slide,
interstate.
The GIS. GIS. You slide it down where I can see up. Slide it. Yeah. Yeah, at the north end of that R15,
There it is.
that is that blue, that was a road that would have connected through at one time. And then just to the north of that, I would like to, because I didn't make a full presentation, I would like to note, those are two R15 lots that are 11,000 square feet. Identical situation to this, where those lots were existing lots back at 285. And I think 5 years ago or so, this board approved those as R15 lots at 11,000 square feet. So this is consistent with that.
No, we're good. This is what I wanted to see. All right, come on up. It needs to be on the record.
At the time that I-285 came through there, I happened to be around at that
I kind of
point in time.
figured. I remember
The
you telling
first
me
road behind there was a gravel road, which is now Cumberland Parkway.
that. Okay.
It was woods between there and the subdivision was all.
Right, but as you point out, Cumberland Park, it's O&I along Cumberland Parkway, and I think what we talked about was the fact that the O&I went from Cumberland Parkway all the way over to this area here.
Years later, when they did the big planning for the whole county, somebody arbitrarily put the property right up against 285 as O&I. But this particular property, the entire front border is cut off with R20. So the entire part of this property that is fronting on Ridgewood Drive is R20.
Correct,
And then
that's the little
O&I
sliver.
fronts on 285.
Right, and what you're talking about is when zoning came into existence in Cobb County in 1972. And you're correct, they put the sliver of R20 along Ridgewood Drive to separate from the neighborhood. Thank you.
Yes, sir.
Similar situation in my neighborhood. It is predominantly R40, but we have lots that are zoned R80 and they're only 1 acre in size. And what you're seeing here is kind of a remnant of what happened when the county had to impose zoning in 1972. But, so the situation is here, and get more comments, but basically you have a 10,000 square foot lot that is currently zoned mostly O&I in a residential neighborhood that its only access is in a residential neighborhood I don't think that this board would want an O&I business to come in because, and remember, we talked about this in our meeting, that with it being zoned O&I, somebody could potentially come in, right, John, and put an O&I use in there.
That's correct.
So, Kelly?
And my, well, I still have.
Okay.
Also with usually with the front setback waived and the rear, we accommodate, but you don't really have room to compensate. But, they do back up one to 285 and one to a road, so it's not encroaching on
Right.
a neighbor, so I guess I could live with that, but, I mean, what other choices are with that square feet?
Commissioner Gamble.
So my only question, Commissioner Ott, is that the homes to the south of these two, they were constructed under the O&I, or they were there and then the O&I was laid upon
My
it?
understanding is that they might have actually been there prior to zoning.
Okay, so are you gonna bring this back under a comprehensive land use plan change to remove the O&I?
We could, that'd be a good idea.
And then also remove the
Now,
O&I
the
from
problem
the
with that,
property to the
okay,
north?
I mean, we can do that. The
Okay.
problem is, now, I think that the owners of the homes where you're talking about, I mean, I think they might not like the fact that we're trying to, in their minds, devalue their property going from O&I to residential, but I think the argument would be, it's clearly a residential neighborhood and shouldn't be O&I.
Correct.
So, John, let's plan on doing that in January for both of those lots that are in that neighborhood.
For rezoning or for
No,
comprehensive? change?
comprehensive, in January, when we do the land use map changes.
Gotcha,
Do you
okay.
know what their lot size
So,
No, I'm going to basically change it from, I'm not going to change the zone, I can't change the zoning from O&I, but I can change the land use designation to LDR.
LDR.
It's already LDR.
So,
What's that? Is it currently LDR?
Yeah,
Okay.
it's up
then-
right now.
Then we don't need to make any changes.
so how did a house get built on an O&I then?
It was built, all right, so prior to 1972, there was no zoning, that O&I didn't exist.
Right.
There was no zoning in the county, and so you own property, you can build a house.
So what came first, the O&I or the house?
My understanding is the house came first.
Correct.
So how in the world, if it was a house there, how did we zone it?
285.
Because there are a lot of places around the county, if you look at the land use map and the zoning categories, that they don't make sense because in some cases, instead of having the land use map like the county has today,
Yeah.
it was just done with zoning. So if there was an area that the commissioners or in the past believed should be office and institutional, they just put that zoning category on it. There was not really a land use map.
Okay.
And Mr. Chairman, the original zoning map from 1972 is hanging up in the zoning office. At that time, it wasn't done with this beautiful GIS stuff. It was done with colored pencils. So the width of a colored pencil is about 200 feet. So that's probably why it got pushed that far out. But all over the county, there's situations like this on older zonings where they don't match up to what's actually on the property.
Okay.
And it really comes down to the fact that the concept of a
Right, I
future land
asked.
use map didn't exist.
Right. Commissioner Gamble, sorry.
and then Commissioner Ott, if you look in the staff analysis, it has the definition of to the east, it's zoning O&I, but then the future land use is a rack. So we would need to clean this up.
Well, to the east is the 285, and that's right. It's not this property.
Right, but that is O&I, yet on this side it is also O&I. So,
Right, but we're changing the zoning. The land use designation, according to John, is LDR.
Correct.
So basically, you have LDR up against a rack,
okay,
with the interstate separating the two.
okay.
They
make
would
sense?
have
Does
to
that make
come
sense?
back in and request a zoning change,
Who would?
the owners of the O&I.
Correct. Well, what's going to happen is their grandfather right now, because they have the house. So if all they do is, if they sell the house and nobody makes any changes to the house, they're going to stay as O&I with a residential use. If they were to come in, say, and tear down the house like some of the other houses have been done, and try to get a building permit, what's going to happen immediately is zoning's going to say, you have a non-conforming zoning, and they're going to make them come in and request a rezoning request to come to a residential zoning, correct?
Correct.
So right now, it's considered, it's basically grandfather condition, which is why this lot is in front of us, is because it's not zoned for residential use. and someone wants to put a house on it. It's not, yes.
Yeah, it's coming. All right, so my other comment is, I'm sorry, I apologize. Go ahead, yeah.
My one other comment is on the site plan, it says 3 stories, but I
That
know the
it-
applicant said it's gonna be 2, so they're
Right.
gonna modify that.
Couple thoughts here. First of all, this is painful. I mean, really understand what you're saying here, but the county's between a rock and a hard place. And we certainly wouldn't want to get both, one side we buy the property, which clearly there's no ability to do that. The other one, we have people that want to protect the nature of their neighborhood. I seldom see Commissioner Ott with this kind of difficulty arriving at a hard decision, because we realize that this is going to be something that won't be popular probably with the neighborhood. But you've seen also that we have to comply with what the law allows us to do or what we should be doing. So I share Commissioner Ott's concern and pain about this. This is probably something that's not going to be popularly received. But on the other hand, we as the elected officials have to do what we believe is the right thing to do. One thing I'd like to say is I've noticed that the minimum distance between the buildings is only 15 feet. I don't see a requirement for a serious buffer, arboreal buffers between the houses to protect the 2 houses on the other side. And the reason I'm only saying that is that the lot's small. The house is gonna probably, take up most of it. It's a pretty impressive house. And I'm really concerned about trying to at least give the neighbors some kind of a buffer to that house.
Yeah, just a little context. And the planning commission recommended approval, and they recommended approval matching the same setbacks as the lot to the north that came in for zoning approval. So they were consistent with the setbacks between those 2 lots. The setback is 10 feet on the north. As you can see from this aerial, actually, they encroached on our property. So that's actually gone to litigation, is that they've encroached over on our property. So the setbacks are matching what their setback is, so I don't think there needs to be any additional buffer. They have a wide lot. They have a chance to do the buffer on their side, but the setback, they chose to put their house 10 feet, or right at 10 feet from our lot, and actually encroached.
Okay, so as.
I didn't bring that part up.
Yeah, well, maybe all I'm saying is that maybe I'm confusing the definition, the front and rear setback. On the map here, which one's the front?
Front is Ridgewood Drive.
That's what I thought. I don't see, so I understand that the front is gonna go from, where did I see that here?
20 feet, which
30
is,
to 20, okay?
which is exactly what the home to
That's
our
fine.
north is.
Yeah, and then the rear is 30 to 16.3. I'm just talking about the buffers on the side.
And that's 10 feet side setback.
But what Parks is saying is that the house to the north, the one where you see the R15,
Right.
that is placed 10 foot from the property line.
We will have the same side yard setback.
And then there's a litigation still going on.
Well, I don't want to get involved in any litigation.
No,
issues here.
reason I'm saying is that there is litigation about the setbacks on the side.
Oh, I see. Okay,
That's
on
why,
both sides.
that's why I didn't bring it up.
Okay, all right. Well, I just a comment, I'm just trying to find a way to find a middle ground here, that to protect the properties that are on both sides, give them some degree of privacy from a house that's, we all know is to be built on a smaller lot. But what's compelling to me is that there are R15 sites already in the area. And, this is clearly not an R20 lot. At best, it's an R15 with some degree of variance. And I think that in this case here, I hear what the neighbors are saying, but I think that the reasonable approach here is to go ahead and approve it. I support this. But just asking for whoever builds the house here to be very, very sensitive to their neighbors, to give them the privacy that they're looking for. So with that, any other comments? Call the question.
No, I made a motion.
Oh, I'm sorry, I thought you had.
No, I asked for comments before I made the motion.
Oh, okay, all right.
All right, so, I make a motion to approve Z24 to 2 stories with a final elevation to be approved by the district commissioner. Subject to all planning commission comments, not otherwise in conflict. Yes, well, yeah, to zone it to R15, that's a request. All staff comments, otherwise not in conflict. Anything else, John? I think that's, oh, you know what, we probably need to include the documents that were submitted, the deed records. So subject to the letter from the law offices of Gerber and Gerber dated October 16, 2018, with the attached warranty deed and associated exhibits, and also the driveway easement that's recorded. And then also the letter from Parks Huff dated May 28th, 2019.
Okay, we have a second?
Second.
Any other discussion? Call the question.
October, no, it's October
August
2018. Is it 20? This is-
And it passes 4-0 with Commissioner Cupid in absence. Okay. Z52.
Z51.
All right, Z51.
Rezoning case Z51, Pulte Home Company, LLC, requests a rezoning from R20 to RM8 for the purpose of attached residential in land lots 693 and 748 of the 17th district. The property is located on the southwest side of the West Atlanta Road, west of West Village Drive. The applicant is present. Is there anyone here opposed rezoning case Z51? Let the record show there's 3 people opposed. All those wishing to address the board, please come forward to be sworn in.
Mr. Bally?
Thank you, Mr. Chairman. For the record, my name is James Bally, and I'm here today on behalf of Pulte Homes on Z51. We're seeking approval of 6 additional family homes, and I just wanted to quickly, I know we're under a time crunch here, and Mr. Rowland, can you stop me when I have 2 minutes left? This originally was Z66 of 2016. We made a promise that we would come back and complete the development once we cleared up some additional property that had a reversion clause in it. So we spent 3 years in Superior Court getting that done, finally got that approved, and the court order entered. And so we're here today to finish what we promised we would do back in 2016. We're seeking RM8. When you apply the code section involving the redevelopment, this was a schoolhouse with asbestos that we had to remove and redevelop the site. It comes out at approximately 8.01 units per acre. To the extent there was any confusion, it was my fault for not calculating that in the original application and stipulation letter. But there you see what you have in front of you. We got PVC around us. West Village owns those other lots where you see the WV. We got GC across from us, the Wellstar on the OS, and additional GC. We touch a community activity center. Directly across the road is a neighborhood activity center. Again, Z66 of 2016, and we're here on Z51 seeking 6 additional homes. There was some confusion about a lot that is located to the left of the site that is not included in that has title issues with 66 heirs, will likely never be resolved. But again, West Village owned property all around us. Across the road is the 4-story, 1,600 thank you, square foot facility. It's been a long day already. And so when you look at the density, again, it comes out, when that's the section that's utilized, it comes out at 8.01, and the code section is 134,167. West Village is at 22.83 units per acre, and we're at 8.01. Just to kind of show you the original site plan in 2016, we were supported by all of the residents that abutted us. The only occupied home by a resident, we gave the 25-foot landscape buffer and all additional steps to support that. And again, this is more of a blown-up site picture. Again, that lot is not included. This is the 6 additional homes. And there'd been some question about whether we were going to do an additional entrance. The existing homeowners did not want that, so we put that in the stipulation. There will not be. Those are the 6 homes. They will be exactly like the ones that have already been constructed, 450,000 and up. These are the interiors of the homes. And these are a view from one that was almost completed, and you can see the nice view you get from the skyline. And they're extremely nice homes, and that's why to date they are selling from 503 to 632,000, even though we said it would be 450 and up. We've agreed to do a master landscape plan that's attached to the stipulation letter for the district commissioner to approve. We're also going to provide that landscaping plan to the HOA, and I guess it's really the current residents, before approval of the district commissioner for their input. And when we initially started out and began to have conversations, there were some security and landscape concerns from the existing residents. So again, the master landscape plan is going to be approved by the district commissioner with HOA input. They also asked that a berm be replaced with a fence. That's in a new stipulation, Exhibit A, that's been passed out to you. I try to comply with the rule about the stipulation letters being filed on time, so you don't have a brand new stipulation letter. You got to match up with everything. Instead, there's an Exhibit A in front of you that will be attached to the rear of it, and the changes are tracked on it, so you can see the changes. But with one or two things that I just spoke with the representative of the residents, and we've added this. So for the record, Madam Clerk, you have the 14 there in front of you. When the last sentence where it says the final landscape plan, we would insert the words including the fence location. And I'll hand this to you afterwards. And then in 15, where it says install a fence, install a 6-foot wooden privacy fence would be inserted there. All the protections and stipulations that were contained within the original zoning are all there. Again, in this letter, with the exception of I no longer need footnote. That was on the very first page, so I'll withdraw that. Number 2, so we won't need that here. But that's what you see in front of you there with the additional matters that we worked out there this morning. 18 of those are not required by the code. The benefits in the neighborhood, real quickly, we paid $300,000 for those of you who weren't here in 2016 for our road, and then donated it to Cobb County to give public access to West Village. We transformed that parcel into one that is producing substantial tax revenue. It serves as a transition from the intense West Village to the south into the single-family home neighborhood, and we invested 3 years in Superior Court to clear the title to complete the development as promised. The current residents are here, and one is going to speak in support, and they support it. They support the 6 homes. Of course, that can result in lower HOA fees with 52, increase the property values, and we've agreed to do the additional landscaping and confirm that the HOA, they made a request not be turned over until the 6 homes are complete. We agreed to do that, and sometimes you don't hear me say this, but I want to thank them, and especially Alette Stachet, and I probably mispronounced the last name, but she can mispronounce mine when she gets up here. But she's been very professional, great to work with on the project. And so I would draw your attention to your staff's analysis, which recommends approval, and goes through the factors that you look at. And then the one I want you to focus on is, are there existing and changing conditions which support grounds for approving the proposal? Staff says yes, consistent with newer development in the area, and recommend approval of the 6 homes. So we ask that you follow staff's recommendation, and I would yield the balance of my time to Alette.
Good morning, Alette Stage. I'm representing the residents of 4400 West, and for the record, I want to state that we have had communication with Pulte Homes regarding our concerns, which were in particular pertaining to the security risk that exposing those new 6 homes would bring to the neighborhood because of the vacant lot, old school lot behind us. That with the inclusion of the new security fencing, we feel that that's adequately addressed. The fact that Pulte has agreed not to put in a second entrance so that we would not become potential through street for the traffic off of West Atlanta Road, and the fact that they have stated that they will share the landscaping plan with us because it was a concern to us that they were removing landscaping that they had already put in place as part of the original build out, that we would get compensatory landscaping throughout the neighborhood so that we could, have as attractive a neighborhood as possible. All those items have been agreed upon, so there's no resistance from the neighborhood right now. We're all pro the 6 additional townhomes, given that we get the security fencing, the landscaping, and keep 4400 West to a single entrance community. So, and that's it.
Okay, thank you, ma'am.
Thank you.
Any others in support? Seeing none, those in opposition?
Good morning, Commissioners. Excuse me. I'm Mary Rose Barnes, representing Oakdale Community Association Board and Cobb County Civic Coalition. We are in agreement with all of the unanimous recommendations of the Planning Commission, the most crucial being the reduction number of units from 6 to 5. The site plan clearly denotes the density of 9.42 units an acre, an extreme departure from the maximum allowed of 8 for RM8 code. PC recommendation for 5 units will result in a density of 7.88 UPA. The applicant had the effrontery to attempt to justify this extreme density by reinventing Cobb County Code 134-167, using a demolition of a school building on the property to allow a density bonus. This is the first footnote, page 1. However, 134.167 requires abandonment of county roads, not demolition of school buildings for a density bonus. I provided you with a copy of the Cobb County Code, which is in total opposition to the applicant's fictitious version of the code. This outrageous ploy should be recognized for what it is, and the code density should be held at 7.88 units, 5 units. The applicant's desperation to maximize profit should not be allowed to trash the RMA code. In addition, if 6 units should be allowed, the combined density with the existing project would be well over 8 units an acre, as the first phase was built at 7.99 UPA. Footnote number 1, page 1, should be deleted in its entirety. There should be no density bonus based on a misrepresentation. In the second footnote of the STIP letter, page 1, applicant is apparently threatening this board with a lawsuit if the RMA code maximum of 8 units is upheld. By removing their voluntary stipulations, if the applicant can't build 6 units, the 5 units could not meet the requirements to meld with phase 1 and could be built with 5 rental units on the property. This statement can only be perceived as a threat to BOC's right and responsibility to uphold the code, either give in to the applicant or face negative consequences. It is an idle threat, but a threat no less. The present residents who paid upwards and over $500,000 for their property would not countenance a haphazard project next to them. Such wording has no place in a request for zoning. Footnote number 2, page 1, must be deleted in its entirety. Footnote number 5, page 2, keeping in line with the outrageous tenor of the STIP letter, specifically represents how the BOC should respond with the wording of any approval of the PC recommendations. Members of this board are very familiar with their rights and responsibility and do not need a developer to school them on the proceedings. Footnote number 5 is overstepping and disrespectful and should be deleted in its entirety. On the face of it, this proposal might be perceived as just one more unit, but your decision will go to the future of the zoning process. Should deliberate misrepresentations, thinly veiled threats, and arrogant assumptions take precedent over the RMA code, the rule of law, and the protection of the public? OCA Board and CCCC urgently and respectfully request that all Planning Commission recommendations, including the maximum of 5 units, be included in your decision, and further that footnotes 1, 2, and 5 be deleted in their entirety. Thank you for your consideration.
Thank you. Other voices in opposition? Seeing none, Commissioner Ott.
Thank you, Mr. Chairman. All right, let's talk about stipulation letters and what is on them and what is not on them. Footnotes are just that. They're footnotes. They're not stipulations. They are sometimes explanations. And I'm a little bit concerned by Ms. Barnes' comments about us being schooled and being told what to put in stipulation letters, because I will point out, I would ask the board to look at number 19. Stipulation number 19. Stipulation number 19, all 6 items, in particular number F, is exactly what the CCCC and other homeowner groups asked this board to put in. So it is not uncommon for both applicants and homeowner groups to ask the board to include things in the stipulation letter for clarification. Number 19 is purely a homeowner construct. Ron Siphon, myself, and staff worked on this. The most important one being F, which has more recently been added, where it says, and the intent of number 19 is to basically say what the district commissioner is allowed to modify and what they're not. But number F is the one that's most recently added, at homeowner suggestions, that a district commissioner cannot make any minor modifications that violate the county code, Cobb County zoning ordinance applicable to this property. So to chastise someone for putting in a footnote that they would like the board to not, about comments, recommendations by the Planning Commission that are conflict. I mean, Planning Commission is a recommendation body, and this board, when we make a motion and put stipulations in place, we're doing what we believe is right. And if an applicant wants to request a certain way it's worded or whatever, it's no different than what homeowners did in number 19. It's just that it's memorialized as a stipulation in number 19, and the number 5 is just put as a footnote. So I think it's just really important to make sure that everyone understands that both sides get the opportunity to request to this board how stipulations can be worded or how they can be put in here. Now, I agree that number 2 needs to go, and it's already been said by Mr. Bally that it was going to be removed. Additionally, one that needs to be removed, and Mr. Bally obviously doesn't remember that we continue to tell Garvis, we cannot have any reference to price points in a stipulation letter. That's just, I mean, county attorney has told us numerous times that we cannot dictate price points. You can tell us in your presentations what you think it's going to sell for, but we can't have that in there. So, Madam Clerk, in the stipulation letter, we'll strike footnote number 4. So with that, I make a, as for the additional lot, I think the fact that one of the things that when we add to a neighborhood, and we are adding to a neighborhood, the folks that live on Benfield Way and Iverson, the fact in my mind that they have come in and said that they support the addition of these 6 homes, and that they got conditions that made them feel better about it. That's important to me because those folks bought in under the conditions without these 6 homes there. And for them to come to this meeting and say that they're okay with it, because the reality is, looking at this, they are the ones that are the most impacted by this change. And for them to come in and say they support it and that they got assurances is very important to me. So with that, I make a motion to approve Z51, subject to Mr. Bally's letter dated August 14th, 2019, with the removal of footnote number 2 and number 4. with the addition of Exhibit A submitted today, with the changes to that, where it says the final landscape plan, including the fence location, shall be provided to the existing homeowners prior to approval by the district commissioner. And then also in number 15, where it says the applicant shall install a fence prior to the word fence, adding 6-foot wooden privacy fence. All other staff comments and recommendations not in conflict. Planning commission comments not in conflict with the stipulation letters and my stipulations. That would be my motion.
We have a second?
Second.
Any discussion? Just one couple comments. I did in fact do the math, Ms. Barnes, and you're right, it comes out to a little over 5 houses. So I hear your point there, but I think the point that gives more weight to me is that they worked very closely with the HOA, and the HOA supports these 6 houses. So, but I do want to acknowledge that, 5 is what would meet the original RM8, but again, I do want to listen to the neighbors since they were the ones that have to be part of that overall environment. So with that, I call a question. Passes 4-0. All right, and then now, I believe OB 41, right?
No, OB 41 was.
That was pulled?
Actually, it was withdrawn.
Withdrawn, there you go, okay. All right, so the question I asked, boys, do you want to take a break for 5 minutes? I know I need to. I know we have all these cases. So we're going to take a break for till 11:11.
And I just want to thank my fellow commissioners, so I can go deal with
Yes,
toxic gas.
you're welcome. All right, let's welcome back from a short break here. And next, we're doing Z40, right?
Correct.
Okay, wow.
Okay, rezoning Z40 of 2019, Larry Herman, request rezoning from GC to LI for the purpose of warehouses and land lot 60 of the 16th district. The property is located on the west side of Canton Road, north of Jameson Road, off of Private Drive, which is Cobb Cherokee Industrial Drive. The applicant is present. Is there anyone here opposed to rezoning case Z40? There's one person opposed. All those wishing to address the board, please come forward to be sworn in.
Good
Okay,
morning.
good morning again.
Good morning, Commissioners. For the record, my name is Parks Huff for the law firm of Sims, Larkin, Huff and Valley, and I represent Mr. Herman in relation to this rezoning application before you this morning. To begin with, the subject property is on Cobb Cherokee Industrial Drive. It's a private road that intersects with Canton Road, just north of Jamerson Road. On the property are two buildings. 5,000 and 6,000 square foot metal buildings. They've been there for many years, and Mr. Herman purchased the property in 1995 for his business. He was in the business of installing billboards, and he used this property for his business for fabrication and staging for billboard installations. And he is now older and has retired. I know sometimes that when these cases come forward and they're the GC removal of your rights, they always like to point out you don't have a business license. Well, I think you have a right to retire. So yes, one of these buildings does not have a business license because he's retired and he uses it for personal uses. The property is one of the ones that we talk about a lot, but I want to drill down a little bit about it. This is a general commercial property. It's on a road called Cherokee Cobb Industrial Drive. It has been used this way since 1987 for industrial type uses. As you can see to the north is a light industrial property. To the south is light industrial property. It has no road frontage on Canton Road, and the property is zoned general commercial. For some reason, the county decided to put this in a neighborhood activity center, like you might have a little knick-knack shop in it, even though it's in, and I don't know if I've mentioned this or not, but it's on Cobb Cherokee Industrial Drive. That's the third time I've mentioned it. I just kind of want to make sure y'all caught that it's on Industrial Drive. And so this is one of the buildings. As you can see there, it's a metal building that you need. This is, for people who have, trades and things like that. This is the type of building you need. It's a metal building, roll-up doors, does not have any visibility on Canton Road. It's not doesn't have any road frontage. It's not a neighborhood type use. This is the other building that is on the south side of the property. It has been used for automotive repair for many years. The other building is what my client, as a retired person, is using it just simply to store his hobby, which is some cars. But it is the southern building is a auto repair. It's been there. So the county has zoned this general commercial. And what I have a hard time explaining to my client is you have general commercial property that you bought in 1995. You used this way. This is general commercial. And now as a retired person, you want to be able to lease or sell your property. And the county says you can't put any uses in there because we took your GC away. And so because we took your GC away, you have to file for a rezoning application, which means you have to pay a filing fee. You have to send out notices to your surrounding property owners. You have to pay that fee. So you're taxing these people who have a general commercial. And trust me, I know y'all deal with this a lot, but to an average person who's owned their property since 1995, it's hard for me to explain to them, the county just took your zoning away. And now you got to bring it in and zone it to something. So the two categories that we looked at is NRC, which is consistent with the Neighborhood Activity Center designation, and that's what the county Planning Commission recommended as a neighborhood activities, as neighborhood retail commercial. But my client's comment is, well, I'm not going to have a shoe store in here. I'm not going to have a Hallmark store in here. These are industrial buildings. I mean, I've been using this as my business for long period of time. I shouldn't be NRC. They took my GC away, and I'm mad. And when you look at the area, you look at the fact you got to your north, you got light industrial, you got some light industrial to the south. light industrial is not an unreasonable use. And quite frankly, these are the type of buildings that entrepreneurs need to start businesses and run their businesses. It provides employment, provides services to the area. And it is on, as I mentioned before, Cobb Cherokee Industrial Drive. So we ask that you zone it to light industrial, subject to my letter, agreeable stipulations, and allow this industrial type building to be used as an industrial use. I understand that, I've had a lot of conversations with Ms. Brown with Canton Road neighbors, and they obviously very much like the NRC category, and that's what the Planning Commission recommended. But when you look at the property and you look at the surrounding uses and you look at the fact that this does not have frontage on Canton Road, it really, I understand my client's frustration that he's owned a property since 1995. The county changed the land use plan from, to neighborhood activity center. And he's got this industrial building on an industrial drive. And one of the conditions, just to drill down a little bit, is in the staff comment said that the zoning proposal will not adversely affect the use or usability of adjacent or nearby properties. That the request will allow similar uses that have been utilized on this property and that are compatible with other uses in the area. It's the staff's opinion that the zoning proposal will permit a use that is suitable in view of the use and development of adjacent nearby properties. The properties have been utilized in an industrial park for many years. The area contains a mixture of commercial and industrial uses. The staff only notes that it's incompatible with the neighborhood activity center designation, but that designation is laid over an industrial area. And I guarantee you that when the land use map you adopt is adopted, this property was not considered in detail. That's the reason why you have that as a vision document and not a zoning document. If you wanted your land use plan to be a zoning document, you would do away with the zoning code and say you're just zoned to the land use plan. So you don't have the drill down to the detail that you have when you adopt a comprehensive plan. And then this gives you an idea of the types of uses that go in a neighborhood activity center: grocery stores, small offices, limited retail. You saw the buildings; those are industrial type buildings. They're not a small office. They're not small retail. They're not a grocery store. And so that is inconsistent with the designation. I would like to point out that the DOT, when they forced this gentleman to come back and rezone his property from GC by changing the land use plan, so you forced him to come back in. The DOT says that his driveway connection to Canton Road is below standard and needs to be upgraded. 2 points there. Number one is he doesn't own it. He's got an easement on Cobb Cherokee Industrial Drive, so he doesn't own it, so he doesn't have the right to make those changes. The other thing I'd like to really point out is that this road, the driveway, this is the driveway in 1993. You can see the wide throat on that driveway, and you can see the driveway today, and you can see how it's narrowed. Cobb DOT, in fact, installed the driveway. When Cobb DOT made the improvements to Canton Road, the driveway was changed. And so if there's any substandard conditions as a result of Cobb DOT, and it should not be as a requirement in the zoning that my client is having to do to rezone his property, even though he did nothing. And now they're saying, we want you to improve a driveway that actually Cobb DOT created, and you don't even control and can't make that improvement yourself. So find that a little absurd, and one of the absurdities of taking people who've had GC property since 1995 and telling them you don't have GC anymore, you got to come back in and put it in either NRC or LI, because those are really the two only categories that make sense given the area and given the land use plan. As I said, the land use plan is a neighborhood activity center, but the definition of a neighborhood activity center does not meet these properties. And that's the reason why staff comment said the zoning proposal as presented is consistent with those, with the area, and is not a burden to the area. So that's it. And I do want to point out too that one of the concerns is the compatibility. We've got residential behind us. The residential came in after the industrial was there. But light industrial specifically has a prohibition against creating noise or emissions of any type that affects the neighbors. So that's not a heavy industrial, it's a light industrial use. So you might have, I'll give you a perfect example of what would fit in these LI buildings. Is I've had a case in Cherokee County where a business was relocating from Cobb County. They assembled drones. Which is a high-tech kind of smaller assembly, but technically that wouldn't be allowed in these buildings. So that's the kind of business that you're discouraging if you don't, if you needlessly limit these industrial buildings on an industrial road. So I appreciate your time and your consideration. Thank you. And I think I had like 5 seconds left, so, you know.
Good morning. I'm Carol Brown with Canton Road Neighbors. I want to give you a little history about the land use. I'm sure you're all aware of it. Back in 2004 and 5, when Commissioner Tim Lee initiated the Canton Road Steering Committee process, Canton Road, the full 5 miles, had really spiraled down. It was in very poor shape. And the Canton Road Steering Committee lasted about a year, year and a half. And one of the recommendations coming out of that as a way to help to revitalize the corridor was by changing the land use from CAC to NAC at the northern and southern end. The Central Business District remained CAC, but everything else on the northern and southern end changed to NAC, and this changed in 2006. It has been a tool in the toolkit for when these many old automotive type uses that were once then they became grandfathered, once they became vacant after a period of, I think, 6 months, and needed to rezone, it created the opportunity for upgrades to the appearance of these properties. And certainly at the commercial nodes, the transformation of Canton Highway is beyond dispute. It's a much cleaner corridor. There's been recent new investment in new buildings. Older buildings have been spruced up, and we've moved away from the heavy number of automotive uses that once existed in the area. So it's been a success. There's no question about that. The other thing that's changed over the years is the addition of many different categories to the NRC code. It's no longer just about neighborhood shopping and pet grooming and beauty salons. It now allows much more intense uses. Contractor is a special exception, animal hospitals, boarding kennels, tool rentals, freestanding self-storage, climate-controlled facilities, and it allows light automotive repair. It allows upholstery. To the point, the fact that this recommended deletion to NRC is not really going to limit the owner of this property from selling part of it to his current tenant who wants to continue his automotive repair that fits in NRC. And I don't think that giving him NRC is going to be harmful to him financially in any way, shape, or form. It's a very viable zoning in this area. And on the other hand, granting LI would actually intensify from the GC. LI would permit, if the property were sold, it would permit a 70-foot high building, where currently he would be allowed under GC, I think, 50, 52 feet. So we believe that the Planning Commission recommendation is the right way to go, and we respectively would ask for your favorable consideration. Thank you.
Okay, thank you. Any other voices in opposition? Seeing none, Commissioner Burrow.
Thank you. Well, first of all, I agree with Ms. Brown. I understand Mr. Parks's points of the rezoning and all, but, you know, the GC category is has gone by the wayside, unfortunately for some, but you are surrounded by NRC and some GC with the LI above you, but that does back up to the residential. And you are now in a NAC, so I think NRC is the more appropriate zoning. And as was mentioned, the owner will still be able to have the automotive repair in the building as a result of that. One thing, and I had discussed this with the applicant and Ms. Brown and DOT, I am gonna suggest that the sidewalks, the redoing of the driveway, come back when this property is redeveloped, not at this time because of the easement to Cobb Cherokee Road, and that's just an added expense that we can't. It would bring it up to our commercial standards that, however, weren't in place when this was initially done. So I am going to make a motion that we delete Z40 to NRC. And with the Planning Commission's recommendations, applicant to continue to use one storage building for auto repair use, which is the existing use, and the other for storage for personal use. Any changes to the use will have to be approved by a district commissioner. And waive the DOT recommendation of the driveway until redevelopment occurs, and then all staff comments and recommendations not otherwise in conflict.
I'll second. Any other comments? The only thing I want to say is that I heard what Mr. Park said about his owner, but I'm really pleased to see that the Planning Commission found a middle of the road compromise by letting him still retain the use of one of his buildings for auto repair. So he can still do his business there, and the other building for his personal use. So this reflects that, yeah, there's changes in the air, and we don't want to impose on them overnight, but there is change, and we're trying to find a way to accommodate this change where both sides win something and both sides have to wait a little longer for something else.
If I could have a point of clarification, the comments, staff comments includes the variances, because the site plan has some variances in it, and that the staff noted those in their comments. Just want to make sure, because it's consistent with the site plan, that the existing site. I just want to make sure that's on the record.
Yeah, right. The only waiver is the driveway.
Okay.
The only exception is
The driveway, right.
of staff comments is the driveway.
That's deleted from.
Right.
Okay, now we do last one, yours? Oh, I'm sorry.
I'm done.
I guess we should call the question, shouldn't we? Call the question. Passes 3-0 with Commissioner Rod and Cupid in absence. And we're good. All right. Thank you very much. We're all adjourned.